but also stands as a testament to our collective commitment towards nurturing our environment and honoring those who contribute to our academic community. This year, Symbiosis Law School Pune Conclave is organized in collaboration with the esteemed NGO Ajivika Bureau. Before we delve into the heart of today's proceedings, let us take a moment to acknowledge the presence of our distinguished guests, whose support and guidance have been invaluable in shaping the fabric of our institution. Please join me in welcoming Professor Dr. Shashikala Gurpur Ma'am, Director, Symbiosis Law School Pune, and the Dean, Faculty of Law, Symbiosis International University. Advocate Archana Pathak Dave, Learned Additional Solicitor General of India, Dr. Banushree Velpandian, Senior Specialist in Law, Research and Networking, Niti Ayog. Advocate Dr. Shrikant Malegaonkar, Director, Malegaonkar and Associates. Mr. Atul Gupta, Partner, Trilegal, as they grace us with their esteemed presence and share their invaluable insights with us today. We would also like to extend our heartiest welcome to the esteemed faculty members, staff members, and enthusiastic students. Ladies and gentlemen, we are delighted to welcome you to the 9th edition of Symbiosis Law School Pune Conclave, one of the flagship initiatives under the aegis of Symbhav. The Symbiosis Law School Pune Conclave is a legal panel discussion and interactive session that seeks to create a platform for meaningful dialogue, fresh ideas, and engagement between India's youth and eminent voices from the legal fraternity. Symbiosis Law School Pune Conclave has a legacy of addressing contemporary and challenging issues. Our past editions have featured esteemed personalities, including Honorable Retired Justice Deepak Mishra, former Chief Justice of India, Honorable Justice Sanjay A. Deshmukh, High Court of Bombay, Honorable Justice Tarlok Singh Chauhan, former Chief Justice, High Court of Himachal Pradesh, Senior Advocate Mukul Rohatgi, the Supreme Court of India, Senior Advocate Sanjay Upadhyay, the Supreme Court of India, and notable practitioners such as Mr. Aditya Patni, Partner, Trilegal, Mr. Navneet Vibhav, former Partner, Shardul Amarchand Mankaldas & Co., and Ms. Tanuji Banerjee, Partner, Khaitan & Co. To begin today's proceedings, we invite our Honorable Director, Professor Dr. Shashikala Gurpur Ma'am, along with our esteemed dignitaries, to join us on stage for the ceremonial watering of the Bilwa sapling, symbolizing growth, enlightenment, and our collective commitment to fostering dialogue and building a more equitable legal framework. Thank you to all the dignitaries. As India undergoes significant economic and regulatory transformation, the landscape of labor regulation is witnessing a historic shift. The Government of India has consolidated 29 central labor laws into 4 codes: Code on Wages 2019, Industrial Relations Code 2020, Code on Social Security 2020, and Occupational Safety, Health and Working Conditions Code 2020. Against this backdrop, we present this year's theme: Rewriting Labor Laws, Assessing the Promise and Pitfalls of the New Labor Codes. The theme seeks to examine the legal, economic, and social implications of these reforms and whether they can balance economic growth with workers' rights and social security in a labor market shaped by globalization, technological change, and emerging forms of work such as gig employment. To set the context for today's discussion and to provide a brief overview of the evolving labor law landscape in India, we will now present a short theme video that highlights the key reforms, debates, and challenges surrounding the new labor codes.
India has just taken one of its biggest steps in labor reform in decades.
4 new national labour codes officially take effect, aimed at simplifying the rules, boosting worker protections and also attracting more investment.
29 separate laws, written across decades and handled by different authorities, have now been combined into 4 labour codes.
The government says the new laws will simplify compliance, protect workers and make hiring easier, especially for the manufacturing sector.
But this is only one side of the picture. 10 central trade unions have called the codes anti-worker and pro-employer and said they were pushed through without enough consultation.
कोई व्यक्ति प्रतिदिन 178 रुपए कमाता है, 178 रुपीज अगर वो अर्न कर रहा है तो ये काफी है, यानी महीने का 4,600 कुछ रुपए अगर किसी की कमाई है तो ये कानूनी रूप से इसको सही माना जाएगा और वो इससे अधिक के लिए क्लेम नहीं कर सकता है। तो आप
छुट्टी तो है नहीं, पर डे काम चाहे 24 घंटे काम करते रहो आप, छुट्टी करने से कंपनी रीडिंग गिरा देती है।
It is now my honor to introduce to you all Professor Dr. Shashikala Gurpur ma'am, graciously sharing her insightful perspectives on the theme of this year's SLSP Conclave 2026. Professor Dr. Shashikala Gurpur ma'am is the director. A recipient of many awards, Professor Dr. Gurpur ma'am has also been conferred with the Distinguished Women Achiever Award from the Society of Indian Law Firm and the Kittur Rani Chennamma Award by the Government of Karnataka for her excellent achievement in the field of education and contribution to women empowerment, to name a few. Former member of Law Commission of India, ma'am has featured amongst the illustrious 100 women personalities in the book The Phenomenal She, launched by the Indian National Bar Association. Ma'am has also been listed among 100 legal luminaries of India by LexisNexis. With 106 publications and more than 335 invited lectures, workshops, and seminars across India and abroad, she has edited a forthcoming book on international law published by Routledge. She is also an editor of a compendium titled Rule of Law in Context, Globalization and Indian Resonances to Sustainable Development, Routledge. With great pride, ma'am, we welcome you to deliver the welcome address.
Good morning, respected Chief Guest, Ms. Archana Pathak Dave, and my esteemed co-panelists, Dr. Malagaonkar sir, Mr. Gupta, and Ms. Banushri, and all my esteemed faculty members, particularly one of our co-presenters, Ajivika NGO representatives here, aside from all the students and staff and other invitees. A very warm welcome to each and every one of you. Conclave represents the most intellectual side as well as engaging side of Symbios in terms of academic engagement. Started about 8 years back, although Symbios has almost touched its 13th year of existence, not 13th, 2008, so that will mean not 13th but 16th year of 18th year of existence. Conclave is pretty new because students thought that there was need for a forum to debate ideas. Although Symbiosis campus, if one enters, it's always full of energy, youthful energies of our young students, debates that they engage in the class with innovative pedagogy and very, very structured, outcome-oriented approach in learning and teaching. But Conclave represents students' own initiative because they wanted to take this experience of their classroom to the national level, international level. We have also had international speakers at this Conclave. I'm very happily sharing with you. Now, year on year, we have picked up themes in Conclave in such a way that these themes resonate with the contemporary problems or contemporary issues or contemporary developments. So we have had also aligned these Conclave themes with the core research focus of the year or thrust areas which are going on in the law school. As I mentioned to you informally, the honorable panelists, and for the benefit of some of the students, especially master's students are here. You are here for a very short tenure with the law school, and some of you might be from outside law schools who have come to participate in the Symbios Fest. I would like to share with you that our themes have varied from looking at globalizing the legal profession, internationalizing legal services, and even in the COVID period, we engaged in hybrid and online kind of debates as part of this conclave. And in the COVID period, we duplicated the conclave as a professional conclave with judges and lawyers, and then we had a student conclave from across the world. Students were responding, especially in one of the most grueling problems of social media and right to remain obscure. So very, very critical kind of thinking went into that. None of these themes have been nurtured by teachers. It is students' own initiative. The whole research comes from academic and research wing of our student body. And they do a lot of research, put the sub-themes together, identify the resource persons, and then they also guide how the process should be. I am only a reflection of what they are doing. It's mostly their hard work. So to quickly tell you how we went about with the response to the contemporary global and national developments and cutting-edge research themes, a few years ago we had our reflections on our Jean Monnet Chair's core theme, which was about European climate change law, policy, and management. So we focused on ESG, and some of our alumni and distinguished partners like Ajay and others, they came. And then we had last year on artificial intelligence and patient safety, which was our heavily funded project from Ministry of Education through IIT Kharagpur. So you'll be surprised how a law school can get into cutting edge science areas, but we are the barometers or bearers and sentinels of justice, fairness, ethics. So that was how we were reflecting to one of the powerful drivers of national progress, namely science and technology, the critical distancing. So this year we are evaluating the newly proposed labor codes, which have been declared to be implemented in November around the Constitutional Day, but they have to be implemented by about April 1st, not very far in the future. Now, why we picked up this theme? Many reasons. Most of our legal aid activities are hovering around our cleaners and other contractual workers whose wages and whose lifestyle, whose life demands, whose family futures, the progeny, and all of that sometimes disturb us, our students, our faculty, and even as members of the community. Secondly, large percentage of Indian population, working population, being under the unorganized sector or informal sector. Third grueling problem, which was beautifully brought out in the documentary that students made, the video, about the dissidence about the current legislation, proposed codes, coming from those who represent the union of these labor. The fourth one is coming in terms of comparative positioning, especially with the app-based gig workers and platform workers. I remember a couple of years ago with the private channel, educational channel run by Advocate Malegaonkar sir, named after his now no more pet Simzoo channel. Some of you should take opportunity to see that. Sir has just introduced the codes about the what of the codes more than in terms of why of the codes or evaluative. So evaluative approach is very important. I would say, as I welcome all of you, this is not just a conclave, this is a consultation. Being in the Law Reform Commission, I know that public consultation is a very important part when you are unveiling new laws. I'm sure that the wisdom of legislature, wisdom of the executive would prevail. Judiciary's wisdom accumulated after we evolved into independence would prevail in bringing these labor code content. But in actual operation, in interacting with the field-based data, how is this code going to throb? So that is what we are going to discuss partially. This is very important because when the code is going to be implemented soon, and labor coming under the scheme of the constitution in the concurrent list, needing the states to have their rules to be setting, and all states being at different degrees of passion or implementation of these codes and the readiness for such implementation, different industrial owners and employment providers or labor recruiters not being aware or not being ready to see that these great aspirations behind these four codes are to be implemented with the same sincerity. We need this public consultation. So you are tomorrow's lawyers, researchers, like some of the esteemed members on the panel. You are some of the advisors to great industries which are there and which are going to evolve as India is poised to be one of the economic superpowers in the future, and already poised to be there with the high growth rate that is being reported. Are these hands really those which are feeding these machinery? Are these really tended? Are these really soothed? Are they really rewarded in a fair manner, even if the aspirations are lying in the words of the legislation? That's what we are going to debate. The possibilities, the foreseen impact, the challenges, as it is rightly said, promises and pitfalls, and evaluation of this code, whether it is a great promise only bounden in the letter of the law, or if it were to breathe life, then how do we do that? Which stakeholder has to take what kind of role? I'm sure will come out of this conclave. That's what I'm hoping. So I welcome all of you, especially Ms. Archana, for agreeing to this at a very short notice. You have really honored us with your presence. A warm welcome to you. Dr. Malegaonkar sir, although our good neighbor, a very seasoned labor law practitioner, not only as a teacher and trainer and practitioner and advisor, but also now getting into the larger possibility of education with this YouTube channel, engagement with major law schools in Pune city. Welcome you, sir. And we have Ms. Banushri, who has been the advisor to the Niti Aayog, a very competent legal scholar. So, ma'am, I'm sure that your research insights will help in terms of strategic understanding of the past, which made it necessary to have this code, and futuristic in terms of what impact can we expect, how Niti Aayog's own initiatives will be lubricating the machinery of slow-moving wheels of justice. And Mr. Atul Gupta is going to be our very important contributor in terms of coming from the top-tier law firm with a lot of experience, insight, and legal intelligence in the core to guide us as to what is the hawa, what is the weather in terms of industrial outlook. Where do you see the law firm's intervention and experience, this to go or progress in future? Is it really going to realize its aspiration as such? How are we in terms of comparative benchmarks from EU or UK or US, especially the Californian legislation, which came all of a sudden during the COVID-19 period to protect the gig workers? So these are some of the questions to which I invite the audience to think about and to look forward to in the esteemed wisdom of our panelists. And I hope all of you have read and come to raise very critical questions with the panel, and also to go home with the accretion of knowledge and wisdom, and also the sankalp or resolution that employment law, I mean the very word labor law, is seen as a kind of unending kind of solution, kind of law, you know. So from there we have to shift our focus in terms of seeing its constitutionality, seeing its place of legitimacy in fairness and justice. So I hope we will be able to convert you into that kind of commitment to do justice to the milieu, who are going to be very important in driving the engine of development in India, which otherwise is unrealized promise in part 4 mostly, and a little bit of it in the sacrosanct apex right of Article 21 in part 3 as right to life and livelihood intermeshed, but not being actually translated into the promise. As we go ahead with the discussion, I'm sure with our examples it will be clear to you why we need to do this assessment and help our government in strengthen our government's hands in seeing that the aspiration of this law is at least met faster than other laws in the best interest of humanity as well as India. Welcome one and all.
We shall now proceed with the felicitation ceremony. As a mark of our sincere appreciation and deep gratitude to the esteemed dignitaries and panelists who have graciously honored today's conclave with their distinguished presence. We now invite Professor Dr. Shashikala Gurpur Ma'am to kindly felicitate Advocate Archana Pathak Dave, Learned Additional Solicitor General of India. We would now request Director Ma'am to kindly present the felicitation to Advocate Dr. Shrikant Malegaonkar, Director, Malegaonkar and Associates. We request Professor Dr. Gurpur Ma'am to present a token of appreciation to Dr. Banushree Velpandian, Senior Specialist in Law, Research and Networking at Niti Aayog. We request Director Ma'am to graciously felicitate Mr. Atul Gupta, Partner, Trilegal. We now move forward to felicitate the distinguished representatives from our knowledge partner, Ajivika Bureau, for their valuable presence and support. We would like to invite them to the stage for the felicitation. We request Director Ma'am to kindly felicitate Ms. Reshma Jagtap, Regional Coordinator, Western Region, Ajivika Bureau. Thank you for gracing us with your presence, ma'am. We humbly request Director Ma'am to kindly honor Mr. Prateek Pawar, Legal Coordinator, Ajivika Bureau, Pune. Thank you for gracing us with your presence, sir. Our chief guest for the event is Advocate Archana Pathak Dave, Learned Additional Solicitor General of India, who represents the Union of India in significant constitutional and statutory matters before the Supreme Court of India. With nearly 18 years of experience in constitutional law, public law, and government litigation, she has also represented the Union of India and the state of Gujarat in several important cases. An alumna of the University of Rajasthan Faculty of Law and an NLM graduate from Jai Narayan Vyas University, Ma'am has served on the legal panels of prominent public institutions such as Engineers India Limited, the Employees Provident Fund Organization, and the Central Council of Indian Medicine. She has also represented major corporate entities, including Oriental Insurance Company Limited, Bajaj Alliance General Insurance Company, and Bharti AXA General Insurance. She has been associated with significant constitutional matters before the Supreme Court, including the Permanent Commission for Women in Indian Army case, Justice K.S. Puttaswamy versus Union of India on the right to privacy, and Prakash Singh versus Union of India concerning police reforms, bringing valuable perspectives on the evolving interface between law, governance, and policy making. Thank you for gracing us with your presence, ma'am. We now request our Honorable Chief Guest, Advocate Archana Pathak Dave ma'am, Learned Additional Solicitor General of India, to kindly deliver her address to the gathering.
Namaskar everyone. Honorable Shashikala Gurpur ma'am, Malgaonkar ji, Madam Bhanisri, Atul Gupta ji, my co-panelists, NGO Ajivika, and all my dear students and teachers. It's a great privilege for me to be here today and share few of my thoughts on such an important topic, the labor codes, the new labor codes. Well, we are here to discuss about the challenges, the pitfalls, and the promises that the present new labor code envisages. Representing the government in the Honorable Supreme Court of India, we come across so many policy decisions which are analyzed, at times criticized, and at times also given a round applause by the Supreme Court. So here also, while we are analyzing the labor code, let's not forget the popular phrase, well begun is half done. I see and I understand there may be few things that require attention, or they may seem easy when it is in black and white, but when you talk about them on practical levels, then they may be really difficult to achieve. But then when I was told about this conclave and I went through in detail these 4 labor codes, there are few topics that particularly caught my attention. And I'll just try and share what I feel about those positive aspects, I would say, and how probably it would be the change that we all want to see in future. Coming straight away, because most of the information is already shared by the person who introduced the topic, but if I was to select few of the important changes, it would be some of the provisions which are regarding the women workers. And I always try to bring about this topic of women workforce, or women who are going out and working in an atmosphere which is welcoming, which favors them in a sense that the particular needs that women have when they go out to work, if that is being addressed, then we can be sure that in future we'll have an inclusive workforce. And that's not just when we are talking about, in the legal profession or in the other professions, but also the labor workforce, which is so overwhelming. I saw this, particular provisions with regard to nursing breaks, which are there in the 3rd code. It was never, this being such an important aspect was never ever realized before. Though there were acts, but on the ground level, we could not see much implementation. Here also, at least when you recognize these important aspects, we can be sure that at least something would be done to achieve those objectives. So first thing is you recognize the problem and then you address that. So nursing break and creche facility. I'll tell you, in my own experience, in the Supreme Court, we had this issue with the young mothers, young lawyers who were there in the profession, and after delivering a child, they were out from the profession for, say, 2 years, 3 years, maybe a little longer if you had another child coming in. And they almost lost their entire practice because there was no one to look after their kids while they were away to work. Now this, I'm talking about the legal profession. We are all here, you are the students, you are our future lawyers, and we are already in the system. But still, this kind of profession where we are fighting for others' rights, sometimes we ourselves don't have those rights. And I tell you with some sense of responsibility that in litigation, this is I think the only place where the lawyers who are practicing on the private side, there is nothing for the women lawyers. I mean, on the other places of work where you have the maternity benefits, you have the long leaves, say in the government sector, and now even in the private sector. But for the litigating women lawyers, there is nothing. So at least from that perspective, in the Supreme Court, we had this creche facility which was opened up, and a lot of young women lawyers and even the staff, now find it very, very positive. They can come with their kids, keep their kids in the creche, and then they can work. So this, I'm talking about litigation, but just see that now this is even recognized. We all must have seen, while passing by the construction sites, at least, while I was going through the, the roads in Rajasthan while I was young, I was very perturbed at times to see young women with their kids. We call that a small jhula, or in our local language, we call it a ghodi. So they have a cloth tied, and the kids are kept there, and the mothers, the young mothers, are working. There is nothing, no one is there to look after them. Now, that small gesture, sometimes provided by the employers, could help them, but now you have it in a structured format. I see it as a very, very welcoming step to recognize that these are the problems faced, and this is how they are proposed to be addressed. The other important point which I found very interesting and important was the concept of the conciliation officers. So nowadays, there is a lot of importance being given to mediation and conciliatory processes, which is also recognized here in the new code. Many a times, it is not important to go through that entire rigmarole of the litigation. It is important that you realize that so many disputes can be handled and settled through processes like mediation and conciliation. If really, in my own opinion, if lot is done in these areas of mediation and conciliation, then we can see that so many disputes which linger on for years together can be actually arrested at the inception stage itself, and that would help. And in fact, we are talking about the labor code, we are talking about the labor force here. It is so difficult. We were just discussing in the morning with Gurpur ma'am that to approach courts is not an easy task. The laborers, to go for everything, to go to the tribunal or the writ courts, it's a very, very costly affair and not possible to achieve at times. So according to me, if more emphasis is given to conciliation and mediation processes, then we'll see a sea change in how the disputes are being addressed. If I talk about the perspective of the Supreme Court, though we have seen that there are numerous judgments on environmental laws and the other areas, but so far as the labor jurisprudence is concerned, we see not really many judgments on this side, but there are few very significant ones which have shaped how the entire jurisprudence is shaped in this particular area. I would particularly talk about the 2006 judgment of Uma Devi, though it mainly talked about how if you have the unstructured workforce or the illegal appointments, you can't regularize them. But then the court did see a point that there are workers, there are laborers who are there in the system for more than 10 years, but they are there as temporary or sometimes just casual laborers. They were not being regularized. So though the law was clarified that you can't have the backdoor entries, illegal entries, etc. But the court, the humane side of the court, they did realize that there are these people who are working for more than 10 years, but they're not being regularized. So there was a cutoff provided, and the court said, as a one-time measure, we would ask them all to be given regularization. So though on one hand, see, Supreme Court in its extraordinary jurisdiction under 142 takes up this task to see that not just the justice is done, but it should also be seen to be done. And in that way, we see this Uma Devi judgment. And now if you have come across and read the latest judgment which the Honorable Supreme Court is delivering on the labors, the regularization, we have a plethora of them. Justice Vikram Nath's judgment, I particularly have gone through Jaggo, which says that sometimes you have to just go by few technicalities, but you have to ultimately pass on the benefit to the laborers. There is also, much emphasis on the beedi and cigar workers in the new code. And we all have read the Mangalore Ganesh Beedi Workers versus Union of India judgment, which said that Parliament has the authority to regulate the conditions in the fragmented industries. Now, all these different aspects have been dealt with in the present 4 labor codes. We will all discuss here. I particularly am placing these important, which captured my attention. I'm just placing them for your consideration. Of course, the panel would also critically evaluate these labor codes. But according to me, being a person who thinks that let's give it some time, whenever, we have seen it in the past, whenever there is something new which comes up, there are teething problems. We are ready to address them, but let's see how they take shape. And also in that process, we'll try and iron out. The courts are there. Once they are, sometimes when they are challenged in the Supreme Court or the High Courts, then the creases which are there are ironed out. And I'm looking forward to the discussion here, the critical evaluation, the pitfalls, so that they can also be addressed. Whenever you are making laws, the government is concerned about the ground realities. But at times, it's only when they are tested, when they are on the floor, then it's the time that you see wherever there are some tweaking required, then that is being carried out. So I'm looking forward to the discussion that would be taking place. I won't take much of the time, and let's begin with the discussion. Thank you, Gurpur ma'am, for having me here. Thank you.
Thank you, ma'am. We are truly honored by your presence and eagerly look forward to your valuable insights during the discussion. We would now like to take this opportunity to introduce our panelists. Our panelists for the 9th edition of the SLSP Conclave are Advocate Archana Pathak Dave, Learned Additional Solicitor General of India. We once again thank you, ma'am, for your gracious presence with us today. It is truly an honor for us to have you as our chief guest, and we are equally delighted to have you with us as an esteemed panelist for this discussion. Dr. Banushree Velpandian, Senior Specialist in Law, Research and Networking. Our next distinguished panelist is Dr. Banushree Velpandian, Senior Specialist in Law at Niti Aayog and a legal practitioner with over 20 years of experience before the courts in Delhi. She specializes in contract and mercantile law, health law, innovation and technology management, ADR, consumer justice, family law, and clinical trial regulation. She holds a doctorate in law on the comparative framework of clinical trials in India and the UK, and has pursued directed studies in private international law at the Hague Academy of International Law at the Peace Palace. Dr. Velpandian has provided techno-legal consultancy to bodies such as BIRAC, ICMR, and the Technology Development Board, and is a fellow of the Chartered Institution of Arbitrators UK and a member of the Association of University Technology Managers USA. She is also empaneled as a mediator and arbitrator, including with the Delhi High Court Legal Services Committee, serves on research ethics committees of leading institutions in Delhi NCR, and regularly contributes as a resource person on innovation policy, contracts, corporate governance, and clinical trial regulation. Advocate Dr. Shrikant Malegaonkar, Director, Malegaonkar and Associates. Our next esteemed panelist is Advocate Dr. Shrikant Malegaonkar, director of Malegaonkar and Associates, and a respected expert in labor law and industrial relations, with over 22 years of practice before the Pune Labor and Industrial Courts and the Bombay High Court. He also serves as a visiting faculty in ILS Law College, Pune, contributing to academic engagement in labor and industrial laws. An alumnus of the University of Pune, where he pursued LLB and MBA, Human Relations, and later completed his LLM. Following academic exposure abroad, Dr. Malegaonkar has delivered lectures at reputed institutions including the London School of Economics, SOAS, the University of Maiduguri, and the Histadrut People's Institute. He has advised and represented several multinational corporations such as Mercedes, Vodafone, Haier Appliances, Magneti Marelli, as well as leading hospitality groups including Westin, Radisson, and Novotel, alongside IT companies, educational institutions, and government corporations. A recipient of the Satalvad Prize from the Bar Council of Maharashtra and Goa and the Samaj Shri Award, he is also the co-author of the book Personnel Management and Industrial Relations with Dr. P.C. Shejwalkar. Mr. Atul Gupta, partner, Trilegal. Mr. Atul Gupta is a partner in the employment practice at Trilegal and is widely recognized as one of India's leading experts in labor and employment law. His work covers senior executive hiring, compensation structuring, workplace investigations, workforce restructuring, social security compliance, union negotiations, and employment aspects of large-scale M&A and outsourcing transactions. He has also established the firm's industrial relations practice. An alumnus of the University of Pune and enrolled with the Bar Council of Karnataka, he regularly conducts training programs on employment law compliance and prevention of sexual harassment, and is a frequent speaker at forums such as the American Bar Association, International Bar Association, Inter-Pacific Bar Association, and the Confederation of Indian Industry. Mr. Gupta has advised legal global organizations including Accenture, Wells Fargo, McKinsey, PayPal, Alibaba, and Prosus, and has been consistently recognized by Chambers and Partners Legal 500, Asia Law, and the Business Law Journal A-list among India's top labor and employment lawyers. Having introduced our esteemed panelists, we are delighted to now acknowledge our knowledge partner, Ajivika Bureau. Ajivika Bureau is a leading civil society organization committed to advancing the rights and welfare of migrant and informal workers through legal aid, social protection services, skill development, and policy engagement. Their association with this initiative will greatly enrich the discussion and facilitate meaningful knowledge exchange on the pressing legal, social, and policy challenges surrounding labor governance and the evolving framework of the new labor codes. Now, we would like to invite Professor Natasha Martin Ma'am, Assistant Professor and Faculty in charge of the Student Advisory Board, to provide an introduction and background of the theme.
Good afternoon, everyone. Before we move ahead with the panel discussion, it is helpful to briefly reflect on the context that shapes today's theme, that is, rewriting labor laws, assessing the promise and pitfalls of the new labor codes. For many decades now, India's labor law framework developed through separate legislations enacted at different points in time to regulate different aspects of employment. Now, these laws dealt with wages, industrial relations, workplace safety, social security. While their primary goal was to protect workers and regulate employer obligations, over time, the system became highly complex and fragmented with multiple overlapping provisions and a lot of compliance requirements. So, recognizing these challenges, the government of India undertook a major legislative reform by consolidating these 29 central labor laws into 4 comprehensive labor codes. These include the Code on Wages 2019, the Industrial Relations Code 2020, the Code on Social Security 2020, and Occupational Safety, Health and Working Conditions Code of 2020. The broader objective of this reform was to simplify labor regulations while adapting this legal framework to the realities of a changing labor market. In particular, the reforms seek to improve ease of compliance for employers, to bring greater clarity and uniformity to different definitions such as wages, and also to extend social security protections to a wider category of workers such as gig and platform workers. One of the most notable features of the new labor codes is the consolidation of numerous laws into a streamlined structure of 4 codes, which is intended to reduce regulatory overlap. The codes also introduce a uniform definition of wages, which helps create consistency across different labor laws. Another development is the effort to expand social security beyond the traditional employer-employee relationships, that is recognizing the growth of gig work and platform-based employment. Additionally, the new framework seems to simplify compliance mechanisms through digital processes, common registrations, and a shift towards what is called the inspector-cum-facilitator model, where regulatory authorities are expected not only to enforce compliance, but also to guide employers in meeting legal requirements. At the same time, these reforms have generated significant debate within academic, policy, and legal circles. Questions have been raised regarding worker protections, the balance between labor welfare and economic flexibility, and practical challenges involving implementation of such a large-scale legal transformation. In other words, while the new labor codes aim to modernize India's labor regulatory framework, they also raise important issues about how effectively these reforms will work in practice and whether they can successfully balance the interests of workers, employers, and the broader Indian economy. With these perspectives in mind, today's panel discussion will explore both the promises and potential pitfalls of the new labor codes, drawing on insights from our distinguished panelists. Thank you very much.
Thank you, ma'am. We would now like to invite Professor Dr. Shashikala Gurpur, ma'am, as the moderator for this conclave, for survey declaration and formally commencing with the panel discussion.
Good morning, esteemed Additional Solicitor General of India, Ms. Archana, and my co-panelists who are on the dais with me, and all the participants here. It's an honor to start this panel discussion. You have had enough of data coming to you from reflections from Ms. Archana Pathak. She has given you the very core values or strengths of this new labor codes, and she has also given you the ideas as to the circumstance under which such labor code was necessary, especially in terms of working conditions of women, besides the dispute resolution mechanism which she is mostly engaged with as a professional. So that must have given you a good introduction, and with Professor Natasha coming in and giving you the idea of what these 4 labor codes are and how they aim at unifying, simplifying the compliance mechanism and avoiding the overlaps, and also with certainty seeing that multiple definitions of, for example, a term called wage does not exist between these different legislations. This is one example of how the code is trying to simplify and universalize. As she said clearly, that earlier the labor law was applicable to organized sector. So here it is universalized in terms of anybody who is employed for even 1 year can be covered by privileges such as gratuity. Now, our initial discussion is going to be taking this format. One is that there has been a questionnaire which has been circulated with various stakeholders. In one way, it also fulfills what I mentioned in the introduction in terms of going to the stakeholders to know the opinion, so that we do a kind of consultation pre-conclave. This is the format students have adopted, so that on an average, multiple stakeholders come there. I request the organizers to beam the survey results here. Overall, the demography of the survey. So N is not mentioned here. I think N is about 136. Yeah. So out of that 136, you see large number of participants are women and 36% are men. Let's go to the next one. So here you will see the age group. As you would imagine, India has 65% of youth, but among our stakeholders, 18 to 25 age group is 74%, 36 to 45 is 7%, and rest of them are distributed in the younger and the older age group. Let's go to the next one. The professional background, if you see, law students are majority because that is our convenient sampling, easily available respondents. So 56% of them are law students, 3% are in-house counsel. Students have taken the trouble to include the trade union representatives and compliance professionals who are usually HR professionals in the organization, because now the law is emphasizing more and more on compliance. Otherwise also labor laws were brought in as the important metric of compliance. Especially if you have read the Ruggie report of United Nations, the General Assembly report, where John Ruggie formulated this report in terms of business and human rights. And most of the provisions of human rights are captured within the work of the Human Resource Department under the labor law. Going forward, it has been brought under sustainability within the ESG framework in the S criterion, environmental, social, and governance. Some portions are captured under S, some portions are captured under governance. So from that point of view, most of the stakeholders have been consulted by our organizing committee students, where you will see legal academics who can come in the category of researchers, in-house counsels, and practicing advocates. So these stakeholders, some of them you can say are future stakeholders in the legal system. Some of them are future stakeholders in the workforce, in employment, being law students. Let's go to the next part of the demography. So that's where we end the demography. Now, as we start the discussion, I would like to commence with Ms. Archana. Before I speak to Ms. Archana, I would like to give you the little format. So we have identified 6 sub-themes. And across these 6 sub-themes, I will be posing questions to each of the panelists in the first round in their area of experience and expertise connecting to these sub-themes. Second is what the survey results show in terms of this sub-theme, so that the audience can get an idea of how the stakeholders feel about it, in addition to what the experts have to say in terms of the provisions. Now, to make it more interesting, I would like to give you a story. I was reading a research report in a very remote part of Maharashtra-Karnataka border from an all-women's university, where 91% of the students are first-time literates, and they belong to SC/ST community, and all women. So these girls picked up always research topics which were dear to their heart. One of them picked up the research topic of migrant women workers. These migrant women workers always migrated from Karnataka border to Maharashtra. So she was one of such children who grew up as a migrant worker, and later on when the university was established, she took admission, and then she was doing her PhD on this theme. So she consulted, as it was easy for her to access and understand, and she had her own pain area brought into the research. So what she shows is that as they migrate, they leave the place, they come to the other state, then they go back. And their education is disrupted, they become susceptible to harassment, very poor working conditions, no question of security because employment is seasonal. They come to the harvesting season of sugarcane crop because Maharashtra border belt is very rich with the sugarcane cultivation, and it supplies almost 80% of the sugarcane produce to these factories which are cluttering the landscape of Maharashtra border in those powerful agrarian districts of Maharashtra, and a few in Nipani and other areas which are border areas. So what we saw here was between two states, these labor force were migrating, and they had all age group people, no security, very bad working condition. If they became unwell, there was no medical facility. So all these she had listed. And at that time I was thinking, what is the way in which these people could be supported? So lo behold, COVID came and their condition worsened. They couldn't cross the border became closed. And they were unknown here for medical facility. They couldn't go back to their medical facility in Karnataka. So she said that it was like from frying pan to the fire. Now, for such people, there is hope in this labor code. What is the hope? The code which is talking about social security is taking care of migrant workers by creating a national registry. So wherever they go, the facilities are availed, because now they get a registration number which is valid across the nation. As the states go through political upheaval, they go through natural disasters, other kind of social problems, then the migration increases. And migration is one of the most unwanted phenomena that we see in modern world, especially intra-country migration. So time and again, if you have done newspaper scan, large number of cases of forced labor, which is prohibited under this code specifically, or the even now different forms of bonded labor, which is being reported in quarry and other places. Most of them are instances where in one particular state, another state's migrant workers are captured or trapped. And these migrant workers come in the early age group, or they come from the disadvantaged gender group or social group, and they are mediated through these dalals or the agents who are ruthless and who bring them here and then just drop them. So they become another number. Now this code has given a validation because there is a national Aadhaar system now, unified identity, and with the use of that they can register on the e-Shram portal. So this is where I want to enlighten you and keep you in context by showing how we can operationalize the actual promises which are embedded within this labor code. So is it all that positive, this promise, or is this promise touching such groups, but is there a larger milieu which is left unaddressed, is the question that we are going to debate. And what could make such aspirations real is something that all of us in a participatory way will think about. So I invite in the first round of question and answer and responses, Ms. Archana Pathak to reflect on 2 points. One is the constitutional context of this reform. What has been the constitutional guarantee? Madam, we had Olga Telly's case where right to livelihood was emphasized by the Supreme Court as part of in an integral part of the right to life. Secondly, we have the equality clauses starting from Article 14, non-discrimination as the core. And then we have right against exploitation in Article 23, where in one of the cases, Supreme Court said that even payment of wages which are less than the minimum wages amount to forced labor. They may not be fully, neatly fitting into the idea of bonded labor, but they are anyway exploitation, a form of exploitation, because it is underpaid worker. So this has been the reflection of the Constitution. Now to get such reflection, Olga Tellis represented the footpath dwellers pathetic situation in her representative litigation. Now, how many people have access to this? Or historically, if we go to 1984 Bandhuwa Mukti Morcha case, there also it was Swami Agnivesh who wrote a letter, and it was epistolary jurisdiction exercised by the Supreme Court under public interest litigation kind of innovation. Now, if one were to connect constitutional provisions and actual availing of remedies for unaddressed labor or workman issues, what do you see is the reform trajectory that we have gone through, and how these labor codes, 4 new labor codes, are reflective of a progressive step in this direction? How are they different? Over to you, madam.
Thank you, ma'am. Well, in my initial address, I talked about the women-centric issues that are there, women-centric provisions that are there in the labor codes. And we are talking about constitutional safeguards. So let me remind you that this, the present labor code is gender neutral. Plus, it also emphasizes on the special needs of the women workforce. Say equal pay for equal work. For so many years, we saw that women workforce did not have the equal pay for the same amount of work which was done by them. So if you look at that, I see that is a very, very positive aspect. You also see the night shifts being permitted for women workforce. And just few days back, I was reading one of the states, the state of Maharashtra itself. They said that they can also, the employers can also see a circumstance where the women can come early and leave early. So these are few of the positive steps which the employers are bound to take now because they surface in the present labor codes so far as the women workforce is considered. Then there is also something which I found very, very positive, that they have added the parents-in-law in the family definition. So while you say that, you know, women are taking care of both the work as well as the home front, but the definition itself did not have the parents-in-law there in the definition of family. I mean, I'm talking about very, very small things which I found very important. And probably they would be the change that we want to see in future. When we are talking about equality between men and women, it is important that we also recognize some special task that is being done by the women workforce. So that's the constitutional safeguard that we are looking at. If you talk about the right to health, there's one other important thing which I saw was also right to refuse work. So this was never there earlier. If one feels that there is some hazardous work that is required for the particular worker to do, he has got the right to refuse. So that is also an important aspect in my opinion. And you see that there are the grievance redressal mechanism which are provided in the code, and it is also mentioned there that there has to be adequate number of women representation in those grievance redressal committees. So when you talk about constitutional safeguards, you have to see right to health, you have to see the equality between the genders, you have to see that special needs are addressed, and in all those spheres we have seen Supreme Court time and again stepping in, and through the judgments that we have seen so far, I think the Labour Code tries to encapsulate the judgments that are rendered by the Supreme Court, and also the practical problems that are seen in the labor scenario, and that's how the present Labour Code tries to address it. So far as the gig workers and platform workers are concerned, they are talking about the fixed term employments, because it's easy to say that still there are so many things that need to be addressed so far as gig workers are concerned. But see, it's difficult to get them into that structure because what they are working is not perennial. You see, sometimes they are just working for few months and then dropping out, and it is difficult to get them entirely into a structured formula. But at least there is an endeavor that is being made in the present Labour Code to get them in some type of structure, and the Labour Code tries to address the problems that are being faced by them.
Thank you, madam. Now, I would like to turn the microphone to Dr. Shrikant Malegaonkar, who has been a long-term practicing labor lawyer in Pune and has been advising national, local, as well as international industry. My question to you is, continuing from what Archana madam told, she spoke about how there is a new kind of protection that is given, especially in fixed term employment, kind of non-traditional forms of employment, and it gets liberalized and flexible. Is this more of a labor-centric reform, or is it compliance-centric reform, which is favoring more the industries and aligning our laws to attract investment and make more global investors to come to India, turn to India? Because right now our ease of business index is not that high in comparison. And secondly, the dimension of collective bargaining. You have been advising trade unions and you have acted as a conciliator between many trade unions and industries. In Damayanti Naranga versus Union of India in 1971 itself, Supreme Court highlighted that in Article 19(1) Clause C, which grants right to all citizens to form associations, that non-interference with this right is very important, and any kind of arbitrary interference should not be done. But look at the time of the case law, 1971. Yeah. Today, what is the situation? And International Labour Organization also highlights the fundamental principles of right at work, freedom of association, and collective bargaining. The question I have for you is, in the new labour code, they are talking about 51% as the threshold for negotiating through the union. And then will it be violative of, or it is definitely violative of ILO Convention 87, which doesn't set any limit, and it says that it's very important to honor the minority voices. Suppose there are less than 51% also, then those voices have to be heard. And the other thing is that what will, I mean, if there is a kind of vigilance kept on this, what will be the implication for, I mean, it's anyway a very unequal equation between the employer and the employee, labor and master. So in such a case, they can afford sophisticated device, AI, and the machinery which can keep a vigil on the activities of the trade union or association of workers. So in such context, what will be the impact on the data privacy and the right to bargain on the part of the employee? So to put it precisely, one is minority voices in the light of the new code, collective bargaining being weakened or virtually nullified in the light of new technological developments such as artificial intelligence, and which may have implication for another fundamental right, namely the data privacy or privacy per se. Over to you, sir.
Thank you, madam. I'll answer your question in some context. First, we will have to understand what was this concept of permanency before I come to the fixed term employment. Permanency in India has all the time been a very prized possession. Rather, Indians go in for permanency in n number of jobs, which is squarely defined in Section 4C of the Industrial Employment Standing Orders Act. Now what has happened is, Industrial Employment Standing Orders Act is subsumed in the Industrial Relations Code itself. And then we say that we have the fixed term employment. Fixed term employment basically was not present at all. Even speaking of state of Maharashtra, we are having the model standing orders. For those of the students who don't know these technical terms, standing orders are, in simple words, rules which are applicable to whoever works in an industry. And there are two types of industries, that is the appropriate government under Section 2A of Industrial Disputes Act is the central government or the state government. Surprisingly, state government in state of Maharashtra does not have, or rather any state government does not have the entry fixed term employment itself. There has been an amendment to the central standing orders wherein this entry has been there. Even today Maharashtra government this is okay, I believe. Okay. So the Industrial Employment Standing Orders Act even today does not have an entry fixed term employment which has been introduced in the labor codes. Now all workers, the workforce put together is under a jubilation. They say that after 1 year they are going to get gratuity. Today gratuity is got by all the workers under the Payment of Gratuity Act 1972, that is after putting in 5 years of continuous service. and everybody is happy that every Tom, Dick and Harry is going to get it after 1 year. No, that is not the position. He will get gratuity only that person who is appointed in the fixed term employment category and not otherwise. Otherwise, the usual gratuity thing remains. And that will be after 5 years. So fixed term employment gives up a flexibility that I want a workforce which is going to exist only for 2 years. Today what's happening, I employ some person after 18 because 18 is the Indian Majority Act. 18.8, that is 18 years and 8 months. After 8 months, 8 into 3 is 240 days. So under section 4C of the Industrial Employment Standing Orders Act, a person becomes permanent after 240 days. If at all goes to the Industrial Code, brings an order that henceforth I am permanent. Now you understand, the employer understands after 18 years and 8 months that he is a good for nothing fellow. He is inefficient, he does not know anything. But the problem is you cannot terminate him. Because if you have to terminate him, there are 2-3 modes. One is retrenchment, one is if at all he commits some misconduct, then by way of a departmental inquiry and all of those. So you have to carry the economic deadweight of this worker who according to you is inefficient till he retires at the age of 60 because the superannuation age in the standing orders is 60. Now what we do? To curb all this, Labour Code has presented another phenomena. I mean, another option that you appoint him. You want him for how many years? 3 years. So you appoint him for 3 years. The only thing is after 3 years, you will have to give him a pro rata gratuity, which would be after, say, for 3 years. That is all. Otherwise, what happened in India, say for example, I was the worker, I worked in A company for 4 years, B for 4 years, C for 4 years, and D for 4 years. My total service is 16 years, and the amount of gratuity which I get is a big zero. So this is done away with. Permanency, on the other hand, is also done away with, because in all of this, permanency is a regular phenomena. But then, I mean, half of the cases in the industrial courts or in Bombay High Courts are on the same phenomena that, yes, grant us permanency and regularize our services. Madam Dave was, while she was giving her address, she mentioned about one thing, that is backdoor entry. Backdoor entry, basically, for all government enterprises, and then we have a landmark cases, Uma Devi versus State of Karnataka, Caste Tribe Union. What happens is, say COVID came up, and you needed people, you needed nurses. So you appointed nurses for 6 months. 6 months are over, again 6 months are over, and these nurses have already landed up in the industrial court saying that we want permanency for the rest of our lives. Where is the money? So government is handicapped that way. Private industry does not have these flexibilities which are now introduced by the labor codes. Next, madam, you asked upon the collective bargaining. Now, under the new labor codes, the unions, especially if I am to talk of state of Maharashtra, there is a state legislation, that is Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971. Today somebody wants a recognition, what does he do? The union, it's an inter-union dispute. So one union goes to the industrial court, presents a set of papers that this is my membership, this is my majority, this, that, and ultimately the industrial court grants a recognition certificate. Now this is done away with in the labor codes. Now it is the employer who is going to grant the recognition, not the industrial court. And there are two types of unions. Now this is an industry, and there is one union which has or enjoys more than 51% of the membership. The employer will say that you are recognized, and that's it. The recognition issue is over. But it can also happen this way, that there are 3-4 unions, and every union enjoys 20% membership, and no union has more than 51%. Then what is to be done? Then the labor codes say, then in that situation, there will be a negotiating council, wherein you are going to have representatives from all the unions. Women representation is encouraged, and all of them are going to then settle the dispute. Now, if at all there is a dispute, mandatorily under the labor codes, or rather the industrial relations code, we have the grievance committee. Grievance committee is made compulsory. Today also grievance committee is there. Today also under section 10A of the Industrial Disputes Act 1947, arbitration is there. But that has become a laughing stock, because till today, nothing has much moved in it. Same like conciliation. Right from when I was a student in LLB and even today, there is a question all the while, conciliation in India has failed, but conciliation should succeed. And this essay is right from when 1947 till today. So when is conciliation going to succeed? Even today we are writing the same questions and the same answers. So the question here is, grievance committee is now mandatory. Any grievance, nobody can go to the court directly. He or she has to go to the grievance committee. Thereafter, it will go to conciliation. Conciliation time period is 45 days because earlier it was limitless. People have entertained disputes before the conciliation officer after 7 and 8 years also. So where is the limitation? And after that, it will be referred to the industrial tribunal because labor codes are abolished under the labor codes. Industrial tribunal will be two types. There will be a single judge and there will be a divisional bench also. Divisional bench will be, one will be a judicial member and second will be an administrative member. And then the usual course, then after that the High Court and ultimately the Supreme Court. So this would be the hierarchy. What government thinks is with this sort of a setup, outsiders into trade union, they will be barred. Today what's happening, I'm sorry to use the word, I have also been on the negotiation panel of so many companies. True or false is a different story, but everybody cannot be painted with the same brush. The thing is, we had so many stalwart leaders. Who is the first outsider into the trade unionism itself is nobody else but Mahatma Gandhi himself. Who was he? Was he a worker? No. But he led the Buckingham and Karnataka mill strike in those days, British days. Then we had people like N.M. Joshi, Sripad Amrut Dange, Manvendra Nath Roy, George Fernandez, all of them. Later, the position has come is that they said there are no leaders of that stature. Some have even, I'm sorry to use the word, some have even used the word extortionists. That they are into extortion. Now with this sort of labor codes, all these outsiders are stopped. I'll give you a simple example. Who is Bal Thackeray? Bal Thackeray, was he a worker? No, but he is the president of Bharatiya Kamgar Sena. Who is Sharad Pawar? Is Sharad Pawar a worker anytime? No, but he is the president of Rashtrawadhi Congress Kamgar Cell, whatever. So every political party has a trade union wing. Now all these outsiders who are not workers, they are done away with. Only workers will be in the grievance committee. So what happens to these outsiders and what happens to whatever XYZ? See, whenever we talk of anything, there are good and bad things which would be happening. So there is an attempt on the part of the Modi government to stop all of these things, outsiders, etc., etc. Then coming to collective bargaining, which was your question. This, in my opinion, would make the collective bargaining position, what it is, in comparison with today, much more easier than what is prevailing today. Outsiders are stopped. Workers have to decide for themselves. Workers can get educated also. Workers, as time proceeds, they will also understand. So it will be a healthy sort of a negotiating and a healthy sort of a collective bargaining is what I feel in the present context. It's a welcome move, as Madam Dave also mentioned it, that it's a balanced approach which the Modi government has done. What they have done is they have taken judgments right from 1947 till today. And whatever are the good elements, they have filtered it and tried to embed it into these 4 labor codes. Yes, ma'am.
Wonderful analysis, sir. In your Symbiosis channel, once we were having an interview and you mentioned about how the re-emergence of platform-based trade unions are emerging. And that was one part of my question also. Where do you see the future for that? And I really liked your synthesis. This is what the current government has done in criminal law reforms also, filtering and synthesizing all the judgments in the relevant area and those novel ideas which came from the actual interface in the courts of law in the form of people's real lives have been brought into the body of this new law, which all students must take a very balanced view in terms of seeing the impact of the past as a reformative trajectory, which Madam also mentioned. Just a quick response, sir.
As far as gig workers, platform workers are concerned, today under Section 2S of the Industrial Disputes Act, which defines workmen, they don't have a category or an entry itself. It's only manual, skilled, unskilled, technical, clerical, operational and supervisory, that's all. Where are gig workers? So gig workers, and today we have schemes, 10-minute order. So you place a pizza, and in 10 minutes he would deliver the pizza at your doorsteps. What happens to him? He is into the same traffic jam, same accident-prone areas. Some have met with accidents also. And we talk of Article 23 in the Constitution, right to exploitation, and all of that. I mean, this is exploitation, which has been taken care of now in the labor codes, because with whatever are the mechanisms, of course, there are going to be schemes which are yet not on paper, or even practically they are not there, but they say they are going to bring up schemes for all of these people. They don't have workman compensation, they don't have ESI, they don't have anything. They just know only one thing, that you and me order a pizza, I used to come running, that's it. That is all what's happening. So let's welcome that move on the part of the government. They have done something for them.
Thank you, sir. Yeah. So before I turn the microphone to Ms. Banushree, I would request the organizers to display the responses to the first four questions, which are relevant to the two themes which have been discussed, the constitutional trajectory and collective bargaining dimension changing with the digital platforming. So first question here, number one question. Yeah. First question is, how would you rate your familiarity with the labor codes? Our respondents, as you have seen, large percentage coming from students and younger age group, they talk about overall moderate familiarity. That means many haven't gone into the depth of it. I hope that already the learned panelists have taken some of the deeper issues. So 34% of them said somewhat familiar. 25% said not very familiar. Overall, some awareness of the new labor code was there, because it beams all the time in the mass media or social media. So somewhat familiar is the larger percentage among all of them. Let's go to the next question. In the next question, we are asking about how do 4 new labor codes make it easier to run a business while still protecting workers' rights and welfare. Now, you have seen a lot of rays of hope as reflected by 2 learned panelists. Divided opinion, with 33.8% feeling that codes prioritize economic flexibility over worker protection, and 23% believing that they successfully balance both the objectives. So larger percentage tries to see the business advantage or economic flexibility. But here I would like to go a little deeper into the qualitative dimension, which I want the learned speaker to reflect on, in terms of how, with the varied kind of contract possibility, which Madam also highlighted, and a lot of these gig workers don't serve one master. They may serve many masters in many shifts, in many patterns. So whether that changing pattern of work is reflected in the law, because sometimes law is slower when technology takes over the whole forte. So from this point of view, after we reflect on the fourth question, we'll go there. Question 3, please. Question 3 talks about, does the increase in threshold for applicability of standing orders, what sir already reflected, means now have at least 300 workers for standing orders to be mandatory instead of 100 earlier. So does this weaken worker protection, because minority voices may be shunned because of this, and affect constitutional guarantees under Article 14, 19 and 21 of the Constitution? To this, 61% said that this adversely impacts constitutional protection. Madam, I would like you to reflect on that when we come back to you in the second round. 12% see no meaningful impact. 6.1% consider it as appropriate enhancement of business flexibility, and 14% are unsure. So the large percentage of them have very strong concerns about this dimension of yours having implications for the citizen protection under the citizenship rights, protected fundamental rights, especially under the Constitution. So that is question number 3. Let's go to question number 4. Question number 4 again comes to the same collective bargaining dimension, where 28% see that it has the potential to provide benefit parity and reduce intermediary exploitation, because now that intermediary, what sir said, disconnected third party. So that has been avoided. 30% feel that it increases employer flexibility at the cost of job security. And they also said that 18% especially say that there could be work workforce casualization rather than workforce consolidation. And 19% are unsure, 3% see no meaningful difference. So this first and second point, especially 30.8% who feel that employer flexibility at the cost of job security might increase. Now, this has to be seen in context. So after this, therefore, I turn the attention to Ms. Bhanushri, who has been both a practicing advocate, a policy advisor. She has been on many ethics committees as well. So, Madam, you are the apt person to reflect on intersectionality of these labor codes. So far, we have discussed about the industrial code. We have talked about the social security code. So now, in terms of talking about these codes, in terms of e-Shram portal, for example, since you are associated with the Niti Aayog, which has been reflecting also on dimensions of technology coming into this, aside from policy reforms and policy watch. So we would request you to reflect on the issue of how far registration of e-portal is going to revolutionize this whole dimension. The important question of connecting it to in terms of protection of the workers. Because when I was studying as a student, social security legislation, if we spoke, labor legislation came on top. Then the family law related legislations. So because economy and economic rights, socio-economic rights are very much reflected in this. So now with the varied kind of employment, fixed term employment, could it translate into a portable, adequately funded initiative? And just by mere registration in e-Shram portal, how far it is going to guarantee the workers' rights? Because already our respondents have expressed doubt over these labor codes being more worker-friendly than industry-friendly. Over to you, Madam.
First of all, I would like to place on record the thanks to the Conclave organizers for putting me here and enabling me to actually share my views. And definitely when we talk about the question of intersectional, as well as the portal applicability and also the reformative prospect itself, we have to know how any reform or any amendment or a revamp of a statutory framework comes into being. We look at it as a divine process, as Niti Aayog. So we say it is a temple of reform. We have always Dharma and Satya, and there's a foundation. And we have at the Sanctum Sanctorum the national ambition and aspiration, which is Vikasit Bharat, and other missions which we come up with. The Dwaraka Palakas or the entry sentries to these temples are speed and scale. The speed of the reform which has to be considered and the scale of it, because we are looking at lakhs and crores of population and beneficiaries, like ma'am says, how to bring them on a singular platform or at least make it seamless as possible. We look at the Vimana as the economic transformation and the Mandapa as the slowly evolving dynamics of the stakeholders and also the fabric of the social inclusion. So this union gives the Mandapa structure for us. So when we look at as a reform perspective, when we actually take a framework and assess its regulatory impact, as well as see what will be the future strategy, it is an interplay and combined with the Kalasha of judicial review. It is going to be the lightning arrestor to protect the very structure what we are talking by its judicial interpretation. So when we look at this structure itself, I see the technological enablement as a protective mechanism and also as a promising enabler. The e-Shram portal or the Shramik Suvidha portal or even these schemes, what we are talking about, the parent ministry, which is the custodian of these codes, is coming about with a lot of manuals for the employers as well as employees. So when we look at this, the unification of beneficiary structure is going to be definitely going to be a revamping structure, and it also will enable the entire stakeholders to seamlessly connect with each other. When we talk about gig workers or an unorganized platform, we also have a joke, when we say, if you go to a restaurant, eat your food there, you are a contributor positively for a GDP of the country. But if you marry the cook and eat at home, there will be a reduction to the GDP contribution what you do. So we have, the way what we see in the way what we see as value generation for our country and for our economy has been slowly getting into a paradigm shift. We now acknowledge the geological and sociological matters and as well as contributions like the stay-home moms and the gig workers, unorganized sector employees who put in their labor, also as economic contributors. So this labor code has enabled actually this vision to be put in place. And we talk about benefits. The lowest of the labor platform, which is going to be totally unorganized, not even having a register, or an Ajivika register, what we talk about, register digitally, which is being enabled. Without that, it will not be possible at all. So the eShram portal, the more and more registrations are going to improve upon. That means we are going to look at more and more employee beneficiaries and more enabling schemes that can be formulated by the policy makers for all the registrants and the proponents on the other side who will be providers for them. So we are also looking into other schemes, convergence, where we are looking at saturation. So that means every scheme where we can actually provide, including microfinance and even credit systems and financial access to these unorganized sectors, they all will fall in line due to this digital platforms what we are talking and their synchronization what we are envisaging. I think it will address a lot.
Thank you very much. So in the light of this, I would request the organizers to beam the next two questions. In the light of what has been very nicely elaborated by Ms. Bhanushri. So question number 5 actually. We stopped at 4. Question number 5 is the reskilling fund made under Industrial Relations Code, which requires employers to contribute an amount equivalent to 15 days wages of a worker, has been laid off to support their skill training, likely to be enough as a mechanism for supporting such workers. See, employers have to separately keep a skills fund. And there is also a social security fund, which is actually coming out of the proceeds of the fining of employer. If the employer is fined for not making adequate non-compliance fine, that will also go to another fund, and this is another fund that they have to see. Now, survey respondents show a kind of cautious, limited optimism towards this. So 26% believe that it is a meaningful transitional support, but 35.1% view it as potentially effective but contingent on proper implementation. The idea is good, but we have to see the implementation. I mean, when the very employment relationship itself is tenuous, the contribution that you make and the interest that employer takes in developing the employee and the commitment shown to that could become on a quicksand. You know, this may be standing on a quicksand. So the advantage or where I see this perspective is in terms of employee taking responsibility for their development and enhancing their value in the labor market. Again, it becomes very individualistic. But the responsibility of the employer for making such profit is put in the code. It is put in the IR code, it is also put in the Social Security code and the welfare code in terms of employer contributing to the Social Security fund for non-compliances under these codes, and then the 1 to 2% of what is not clear, 1 to 2% of the funds total funds, I believe it is profit, like the CSR, it is different from the CSR, aside from the CSR, must go into such Social Security fund and skilling fund. So I see hope there, but the survey respondents are remaining unsure and they feel that it may be limited due to structural and funding constraints. This is a very important point because we have large number of small and mid-level enterprises. So that is where this could be structurally facing a roadblock. Let's go to the next question. The next question is question number 6, Digital Initiative eShram portal, directly connecting to your response, which registers workers in the unorganized sector and creates a national database to facilitate access to welfare schemes and social security benefits, improve the inclusion of such workers. So they said practical limitation because for these level of workers, even though they have a handheld design, handheld device to call their friends and family and watch some movies, etc. When you ask them to register on the portal, they need a support. So we need our services there. Secondly, 35.4% acknowledge improved inclusion, but highlight implementation and outreach gap. That is our problem. Technology is there, but how do you go on the eShram portal? eShram portal has to be user-friendly, and it has to be, the data has to be translated into planning and implementation process. 14.6% felt impact could be minimal. 14.6% flag potential digital exclusion. Again, that's a very important. This is all built on the basis of digital divide and digital inclusion and digital literacy. So that could be a condition, precondition for the success of this provision. Let's go to the next slide. Question number 7 talks about gender equality provisions under section 3 of the Code on Wages and maternity benefit framework under Code on Social Security adequately address workplace gender vulnerability. Before we discuss the outcome of the survey, I would turn the microphone to Atul to talk about what has been his favorite area in terms of employment laws, being in the top tier law firm. Mainly, I would like you to reflect on the ease of doing business, because you are representing that top tier law firm. Definitely you should be facilitating transactional and transnational businesses. And how do you see compliance here in terms of consolidating the compliances? You know, compliances are more about self-compliance rather than externally enforced litigational or regulatory approach. So here, because they may give fixed-term employment, how will they sit with the gender and other dimension? Aside from that, how will they be increasing our score internationally in ease of doing business? Do you see a large scope? Because as I already told, it has implication for human rights, it has implication for ESG, it has implication for transnational compliances. And one subsidiary point there, you could say, in terms of how new age lawyers who are going to come may find more employment opportunities because of this increased compliances, how they could bring it into their learning and skill building. So these 2 points, if you could reflect. Thank you.
Thank you. Thank you so much. Now, I'll start by saying, this is one of the subjects which begs everybody to give it the type of deep thinking that many other topics do, but unfortunately it's never typically a core topic of discussion for most people, and especially not in law schools. So I'm very happy to see that we have such a distinguished group of people talking about the labor codes. I personally have been now practicing in this field for almost my entire career of about 2 decades. And the labor codes, at least since 21st of November, have become my day-to-day area of advice for organizations. Now, ma'am, your question was, what do they do as far as ease of doing business, right? I think the labor codes have certainly helped to a great degree, or I anticipate that they will help and build more confidence in India as a destination for business through a few aspects, right? As practicing lawyers, we often are dealing with situations where clients get pulled up for minor non-compliances. You have, because labor law is a concurrent subject in our constitution, you have state laws, you have central laws. Now that hasn't changed, right? That's certainly still the case. And in addition to the 4 codes, the existence of state laws is still a reality. So if you're a commercial establishment, you will still have to deal with the Shops and Commercial Establishments Act and variety of rules, etc. But the problem is that today there is a vast number of records, registers, filings that organizations have to continuously make. To a certain degree, the goal of the codes, at least when it came to all the central legislations, is to try and minimize that or reduce that, correct? Proof will be in the pudding in terms of how it's actually implemented. correct? So it's a bit early to comment as to how effective these measures are going to be, but at least the concept and thinking behind it is certainly right, correct? You are talking about moving away from multiple registrations under the Factories Act, under the Contract Labour Act, under the BOCW Act, etc., to a common registration, correct? Which is certainly going to be helpful. Similarly, you are trying to bring down the number of records, registers and filings from a multitude of those under various laws to a smaller number. So I think to that extent the codes have their thinking in the right place. I feel it's going to be over the next few months or years where we actually see how this ends up being implemented. The thinking is also right in saying that we want to move away from being enforcers, inspectors to facilitators, right? Inspectors come facilitators. For that to be effective, in my personal opinion, you will have to train the inspectors, because you can't flip a switch and become a facilitator overnight. Today, the attempt of most inspectors is to go in, demand the right respect and attention, seek the necessary documents. If you don't get it, you're getting a notice, right? And I'll come to that. The notices then translate into proceedings typically before a magistrate, correct? So now the hope is that the inspectors will, over a period of time, change their thinking, not with the idea of, I did not see an attendance register here, I'm going to send you a notice and prosecute you, to please do this so that we can ensure compliance and, you know, not jump to trying to prosecute. I think that thinking will have to change. It's not going to happen overnight, but at least my hope is that it will happen eventually, and that the government will actually put some active effort in training the current crop of inspectors to start thinking like facilitators, right? Just changing their designation is not going to be enough. The third area where I think the codes are certainly making an improvement is reducing the number of instances where organizations get accused of a criminal offense under the law, where any non-compliance whatsoever resulted in a criminal fine and or imprisonment, which effectively ended up being a criminal proceeding before a magistrate, right? And as was the case, always notices went to the board of directors of any organization, requiring their personal presence at least once before that can be exempted. So it became a matter of huge concern and often nuisance for organizations, and they would think several times over. You know, India is a great destination. It's bringing the best of resources in terms of actual facilities and infrastructure and people, right? But if we are going to be on the hook, and our management is going to be on the hook for everything all the time, is this then the most conducive business environment, right? Which is what I think the codes are trying to change. The attempt across the codes is balanced in the sense that we are not going to start initiating criminal proceedings for the first non-compliance. You would be fined. For repeat non-compliances, there might be, right? And there is obviously an increase in the fine. So they're trying to balance out the fact that, we don't want to take it easy in the sense that you should not be let off with a rap on your knuckles if you're non-compliant. But at the same time, we don't want to pull you before a magistrate and start accusing you of criminal prosecution for any and everything, correct? And of course, where there is death, there is injury, where there are serious issues, there is a balance to say that, something like this could potentially be still a criminal issue. So I think in these areas, the codes are certainly a step forward, right? And they will, I feel, subject to how they are actually implemented, instill a lot more confidence, hopefully, in the industry in seeing India as a more and more attractive destination to do business in. But at the same time, I feel there could be many other areas where the codes could have done better. advising and consulting businesses and legal heads and compliance officers in all organizations. And these are global companies who do business not just in India, very often across the globe, right? The one thing that organizations value is clarity and certainty, correct? I feel to a certain degree the codes have missed the bus. And it might not be the most popular view, but I would like to say it as it is because I'm dealing with these issues on a day-to-day basis. There could have been several areas where when you're undertaking such a large legislative exercise, right? It's not an exercise that you're going to repeat anytime soon. After decades, you have taken away laws and put them into 4 codes. The first time. And don't anticipate that this is going to happen anytime in the next many decades again. Correct? Exactly. So when you're taking up an exercise of this nature, I feel there could have been some more thought in addressing the key areas of friction that constantly arise. So just an example, right? And I feel about this quite strongly personally. Today, who is a worker itself can become such a fundamental issue of debate, correct? And can take years to come to an outcome when you ultimately go to court. Now, I deal with clients across sectors, right? I deal with clients in the manufacturing sector, I deal with clients in the pharmaceutical sector, I deal with clients in the ITS sector, which is a very big and a very, very important area of business and employment in the country. Now, let me give you an example. The typical understanding, traditional understanding of worker is blue collar, you know, sitting, working on a factory assembly line, they are workers. But that's not how the definition is. The definition is wide, as Malikaukar sir very clearly put it. It covers people in skilled roles as well, which could be well-educated individuals. Now, the benchmark in today's definition of who is a worker or not is really the nature of their responsibility. The moment you get into a more responsible job, wherein you are a supervisor or a manager or an administrative capacity, you cease to be a worker. Now, is that really the right way of defining worker? Ultimately, if the goal is that you're going to give access to workers to the protection under laws like the Industrial Relations Code, the protections against unfair termination, the right to adjudicate disputes and grievances, access to grievance redressal committees, should that right be dependent purely on whether I am a supervisor or manager or some other economic criteria? I'll give you an example. Small sector manufacturer has a factory, employs a supervisor whose job is to oversee the assembly line. His job is a supervisory job. Tier 2 city earns 30,000 rupees a month. That person is not a worker under the definition. Bangalore, tech company, graduate from a good engineering college, earns 3 lakhs a month, does software development, correct? Now that person earns 10 times more, but has no supervisory capacity, no supervisory role, no managerial administrative role. That person is a worker. Now, whose interest would you rather protect? The person earning 30,000 or the person earning 3 lakhs a month? The worker definition, and see, there is an economic criteria still in the definition. It's always been there. It's been revised from 10,000 to 18,000 only for supervisory category people. So if you're a supervisor and you earn above 18,000, you're not a worker. If you're a supervisor but you earn below 18,000, you are in fact a worker. Now, I find that personally could have been an area where this legislative exercise could have done better, right? If the goal of the law is to protect the most vulnerable, where is the logic to not offer protection to a supervisor earning 30,000 a month, but to offer protection to a well-qualified engineer earning 3 lakhs a month? And this is just an example. And I'll tell you why this becomes so problematic is every dispute, right, in certain industries now has to go through this ambiguity of clients saying, I am paying them so well. These are well-qualified, capable people. They will easily find another job, right? Why am I being dragged through the process of a labor court if I have to let go of somebody because they were a bad performer, right? Why do I have to go through those rigmaroles of complying with all these procedures, right? So I feel that's where the courts could have done better to create a lot more clarity and certainty rather than leave it to obscure subjective criteria, right? Who is worker? Does he supervise enough or not? He's supervising 2 people. Is he a supervisor? Or should he be only a supervisor if he's supervising 20 people? You're leaving it so open to interpretation, and that's not what the industry wants.
Since the consultation window is still open, why don't we write to them?
Ma'am, I have written to the government several times. I have written articles over it. The industry has written several times, right? So this is
a major
let me come in
try to
onto
send
this.
grievances to lawyers like you or to Dr. Malegaonkar. The very idea of worker supervisor.
If we see the just cross-section of the judgments in recent years, one thing is there, say for example IT, 3 lakhs, the dominant nature test as to what is the core area of his duty, whether it is creative, whether he innovates, whether he uses intellectuality. Now we say that in everything, in every job, just to lift the bottle also some intellectuality is involved. Then what is the extent of that? All of those factors, if we see the recent judgments, earlier who is a workman and who is the boss in a way was hierarchical. That I report to him, he reports to him, he reports to him. So it is hierarchical. Today they said, no, it's not this way. I check your work and you check my work, and we both are on the same plane. And with new managements, there are n number of judgments. Say, I believe Vandana Joshi's judgment is there, Abbott Laboratories' judgment is there, wherein courts have enshrined and hit on all these aspects. That yes, it's not only this, but the nature of the duty in the changing environment, because whatever were the yesterday age theories, we have left behind in annals of history and all of those things. So the question now is that yes, things would be changing, especially after 1991 liberalization area. Judgments are also changing, but yet the dominant nature test, it still remains in the sense in the courts of law unless that is changed. But then what do we change for that? One thing, as far as who is a workman, one who sits in an AC cabin, say for example bank workers. Bank workers or all these whoever, what they do is there is some law, I don't know, I forgot to read it in law college, but after 4 months they have to go on a strike. Bank employees and Air India pilots, every 4 months you read the newspaper.
Who are workers, by the way.
They go.
Pilot, the captain of
pilots go
are
on
workers.
strike. And then since childhood, I am taught that who is a worker and who is a kisan. Poems have been written. Bharat ka vaibhav hai kisan, shramjivi manav hai kisan. But where is that shram with this person? He sits in an AC cabin and every 4 months they are going on strike. The Board of Conciliations have been appointed, this, that, so many things. But the question remains that ease of business, that was the thing which we are. One thing has happened, it will certainly easen up the business thing. I am an employer, I am an entrepreneur, I go to the bank, I take a loan, I bear the brunt of it, I face the market risks, everything. And after everything is settled, then some Tom, Dick and Harry trade union leader comes and starts negotiating with me. General demands, every 3 years, they are changing everything. In the sense, they want, say last time the agreement was crystallized on say 18,000 rupees is the increase per month. After 3 years, he says, you talk something more than 18,000. So minimum wages is 18,000. Then we gave you 18,000. Now you talk more than that. Leave and holidays. I was surprised. We were into a negotiation with the union, with Philips. And some company policies are also funny. Normally under the Factories Act, 30 days is the leave. So you can give 31, 32, 35, whatever, little bit here and there. And then at Philips, they give 75 days of leave. That's the company policy itself, because they want all workers should go rest, this, that, and then their mind is fresh, whatever. May not be with all other companies. And as Atulji said, a simple example is a worker in Mercedes. Here he gets 90,000 rupees, then there is a wall, and then there is another company. That other company, the manager gets 30,000. Here the worker gets 90,000, there the manager gets 30,000. We go by the definition. Ultimately, law is blind. In courts.
Isn't that the ambiguity, as he said?
Ma'am,
that needs to be resolved with
I have
some
one
kind
point
of
to make in this.
Yeah.
It is always the bottom of the pyramid approach. Every sector, the threshold of minimum wages or the package, what we call, for an entry professional is going to be different. You cannot have 18,000 and 80,000, that may be the only ambiguity. No, it is not like that. Every time, every sector we look at, there is a bottom pyramid. Who are going to fall prey? Who may be exploited? So that is where the definition is going to cover. So there has to be some balance in that regard.
So the point I'm trying to make again is, what's the objective? If your goal is to protect people, what is the benchmark for that? Is it their roles and responsibility, or is it their position in the economic strata, which is they are the lowest paid employees? It doesn't matter if they have responsibility. Ultimately, should it be an economic criteria to say, I believe that people earning up to 50,000 or more should be treated as workers? Anything about that? No. And keep evolving it with changing times, cost of living. Rather than keep it vague, subjective, what is somebody doing, not doing? A pilot is a worker.
In workman dynamics, dominance matters. That's what sir was also supposed
But that
to.
is a vague criterion. You have to concretize it. That's
Ma'am,
what
that
he's
is where it comes. It is a skeletal legislation. If you treat all the 4 codes, it is only an enabling legislation.
Could it have these criteria?
It is a concurrent list, so every state is coming out with its rules.
Yeah,
so,
but then what is wrong in giving a common denominator is the question. A common denominator, basic minimum you give, then they can evolve it. Otherwise, they'll violate the very idea of vulnerability, because vulnerability
it is always fun for lawyers to interpret, ma'am. Even if you find a common denominator, we will find a differential measure to it. So that is fine.
That's all right.
So,
but in legislation, that has to be there, because otherwise judges will be confused. Judges will be left with no guideline.
Madam, the question is to be answered.
Yeah.
Ease of doing business. The biggest eyesore for all these trade unions is increasing the standing orders limit till 300. Today it is 100. Chapter 5B of the Industrial Disputes Act applies after 100 workers. So for retrenchment or closure of an industry, you have to take a government permission.
Yes.
Which is now 300.
Now it is stretched to 300. One thing is not defined anywhere. What would be the set of rules from 0 to 300? That will depend on what we negotiate with the grievance committee, or the negotiating union, or the negotiating council.
True.
So all our lawyer friends who are sitting in front of me, they are going to have a fine time drafting agreements, whoever goes in this. That's a big area, which is a new one, which was never tapped on earlier. Because from 0 to 300, model standing orders are going to start at 300. So what are the service conditions earlier to 300? That will depend upon your contract, which is defined under Indian Contract Act 1872.
So this is something that could come into the curriculum, as I was asking him that question in the training process. Is there any other point quickly you want to add, and then we can proceed to survey? And
No, so I mean, I feel to the question of what young lawyers should be thinking about, I feel, and I'll talk from personal experience, in at least the corporate law firms in the country. Labor and employment law as a practice area has been one of the smallest practice or non-existent ones. Me personally and my firm were probably the first in the country to actually focus on it. But I can say with certainty that this is going to be a very, very prominent area. And especially with laws like this that are coming and evolving continuously, and human capital. We are a country of 1.4 billion people.
So students who are there, you please pay attention to this point. When I ask each and every student, what's your career goal? Corporate lawyer. And you think that corporate lawyer is a very straightforward corporate context. No. The labor law always forms the fulcrum of the corporate law because it is one of the, it may not be having the direct tangible area like finance, but it is human capital, which is a very important investment dimension. So please pay attention to that point. Yes, please go on.
No. So I was just saying that this is one area where there is a huge prospect for growth. Very few well-experienced labor and employment lawyers today in corporate law firms. Significant mismatch between the amount that has to be done in this space versus the willingness of students and young lawyers to actually actively participate in this area. So I think huge opportunity and very, very fulfilling. No two problems are the same. This is not just numbers on an Excel sheet, not just representations and warranties in a share purchase agreement which are standardized. Each problem involving workers is unique.
Very good. True. Excellent. Thank you very much. Now, in the light of this wisdom, let's go through we have 12 questions in total. We have come to the 7th one, which is looking at one part of the code, which is about OSH or occupational safety and health and working condition code. So in connection to that, gender equality provisions under section 3 of the code on wages and the maternity benefit framework on social security adequately address workplace gender vulnerability. The survey shows that doubts over practical implementation, of course this is one doubt, weak in enforcement 36% say, 16% say that it adequately addresses, 27.7% feel protection remains only partially adequate. So there is a hope, but there is also doubt about that. Let's go to the next slide. The next slide is on question number 8. Should gig and platform workers defined under section 2, clause 35, section 2, clause 61 of the code on social security mainly rely on market-based income determined by demand and platform work rather than labor protection provided by law such as social security and other benefit? So this is, should it be market-based income than labor protection? Now, what is the answer? Balanced regulatory approach is advised by survey respondents. 39% say that combination of earning as well as statutory protection should be balanced. Then 25% say that market dominance with limited statutory protection, and only 11% solely say that market mechanism should be important. So our respondents have been balanced in their view, but what is the reality? Does anyone panelists want to respond on this about gig and platform workers, either you or practicing from the practitioner side? Sir, quick response to this.
What would happen? As on today, there is nothing. First time some introduction is there. Gig and platform workers, rather, gig and platform workers have found an entry for the first time in labor codes itself. Earlier, right from 1947 till today, none of the judgments, nothing. Some unions have made attempts to file cases, and then all the cases were naturally dismissed because they don't fall in the category of workmen only. Section 2S of the Industrial Disputes Act does not apply. Now, for the first time when it comes, these are something which we never contemplated. I mean, there could be such services, platform, Ola, Uber, drivers. They don't own industries, but they own only a platform. And on the platform, they do business, and the business is huge. So they also require some schemes which I believe they have guaranteed in the labor codes itself, that yes, Pradhan Mantri Yojana, Desai Yojana, that they are going to frame up.
But sir, if you look at the comparison of UK, EU or California legislation, in the UK law they are looking at worker limb which exists between someone who is self-employed or a traditional employee with the availing of minimum wage and holiday pay. Whereas in California law, it has followed a hybrid model where workers remain contractors, but also they get guaranteed earnings. So there is a kind of social security which is provided, and health subsidies are given like a traditional employee. So should they be treated as piecemeal contractors or traditional employee? In this facet, UK follows a hybrid model, California follows a strongly contractor model, EU adopts a more liberal perspective which says that any app, if it controls the work of a person, then they become gig employee. So it's a broader definition, more liberal definition. So they are treated like an employee, not as a contractor. So what is our approach? Yeah.
So ma'am, this is a topic which I have written extensively on, right? And I'd like to take a few minutes to share my perspective on it. The gig economy has blown up over the last decade, correct? It didn't exist before that, the concept. Though India has got the highest number of people who are quote-unquote self-employed. Your vendor selling fruits on the roadside, the coolies at a railway station, right? But the concept of gig economy driven by technology has blown up over the last decade, which has created a lot of opportunity, and it's come also with a lot of quote-unquote abuse, right? Undoubtedly. Now, one might ask, compared to other countries, why has India not seen actual developing robust case law and jurisprudence on how these workers should be classified? All these other countries that you refer to have had multiple judgments now, where the question of whether a gig worker, like a Uber driver or a Deliveroo rider, etc., whether they should be treated as employees / workers or not. India has not seen such rulings. One might ask why, and as Malakarkar sir said, there have been attempts to go to the court, but many of them have actually been withdrawn. Not just been dismissed, they have just been withdrawn by the unions. Now, I feel it's a very complex set of circumstances why we are where we are. One of them is the fundamental concept of minimum wage. Today, a Uber driver, with all the challenges that come with being a driver, which is long working hours, no protections, still potentially makes more than what they would get if they were a driver in a company earning minimum wages. The minimum wages in this country, in most states, don't go beyond 18,000-20,000 rupees for skilled jobs. Now, if I fight for worker status, I am a worker, what is the risk? Okay, sir, you are a worker, I will pay you a fixed income, I will make ESI contributions, PF contributions, but then your income is fixed. And I could keep it somewhere close to the minimum wage. Is that what those workers want? No, I don't think so, because their earning potential is then at challenge. It takes away the flexibility that they currently have to work on multiple platforms.
So what could be the solution in such a case?
So, which is one of the reasons, so I feel, right, something like this is not one easy solution. What the codes have tried to do is they have now given these workers a separate category by themselves. By definition, they are falling outside the traditional employer-employee relationship. Fundamentally, now the chance of them saying I am an employee reduces. So, to that extent, now gig workers by definition are a separate category.
So, like Karnataka has adopted a separate legislation on them, do you think that if the labor code, newly proposed labor code, can incorporate such points like the best practices of other nations?
So these are, yeah, so what is happening is in India, effectively, I think the approach has been balanced because what has come out is these gig workers have said, listen, I don't have social security. My car is in an accident. I have no insurance. Correct? I have no fallback. That's what they're asking for. They're not asking for regulated working hours. They're not saying, I will only work 8 hours a day and that's it. They're willing to put that extra time and work. It comes with greater money. But what they're lacking is the social security backing. So the code's approach fundamentally is not wrong in my opinion. They are creating a separate category and they're saying, we will give you social security cover, which many platforms were doing on their own. Right? So now implementation is where they'll have to be seen whether it's effective or not. 1 to 2% of the annual turnover, up to 5% of what you're paying, those are the contributions that have to be made, right? It's going to increase obviously the cost of the service because that is going to get passed on to the customer. Now, whether this is going to create an ecosystem where genuinely people can go register and get access to these schemes and say, yes, I feel I'm protected, needs to be seen. In many countries, they are not creating separate schemes, especially for gig workers. They are part of the regular pension provident fund systems. Over here, pension provident fund is only for the organized sector. You have to be an establishment with 20 or more workers to be even able to register under the PFI. Correct? So now they are creating a completely parallel social security system, which hasn't actually started working, to the best of my understanding. But conceptually, I think it's reacting to what the workers themselves have asked, which is greater income, but with the promise for better social security or fallback.
There's one more example, madam.
Yes, sir, quickly.
See, somewhere in 1890s, there came a proliferation of educational institutes. So many. We are also one of them. Some people started engineering colleges. What is the prime object? That he'll be an engineering graduate. After an engineering graduate, do what? Go to the government and ask for a job? There are engineers who are employed in Jilla Parishads. There are engineers who are employed in corporations. They are government or instrumentalities of the government. And they are getting paid a little bit higher than the minimum wages. That's why these people have also ganged up into unions and filed general demand cases against the corporation, which are even pending in industrial and high courts today. Everywhere, the same thing. What was the object? Do you want a job, or the idea is that you have an engineering knowledge, then you start a garage, do something, small factory, you will also grow up, or you are all the while dependent on government that come on, give me minimum wages, and that's the end of the story. Otherwise, give me social security schemes. Same with gig workers. Little bit of a difference, but then tomorrow, schemes are introduced, we have yet to see the test of the time as to how much it is. But then some gig workers, he has got a private taxi, he owns the taxi, he is the driver, and he earns more than the minimum wages. And minimum wages today, they are talking of a floor wage, which would be constant all over India. But there are industries which are closed down. I'll give you an example, Racold, those geezers. I was representing Racold, and some agreements were made. Wages of the workers were 45,000 rupees. Then came Modi government. Modi government said, shift to northeast and Panchkula in Himachal and here and there, and we'll give you huge subsidies, which they granted. Now you see, in areas like Imphal and this and Agartala and all of those areas, minimum wages is not 18 and 20,000. It is very, very less. So this had an impact on the cost price. What happens to the company here? Answer is very simple. It got closed. Finished.
Then we have this, at least in media cases, we had this city-based compensatory scheme, right?
Now you see, if you see the picture altogether, ultimately you have to compete in the market.
We have to renew the regulations as per the...
see, we can just...
Less to regulate and more to facilitate. So,
exactly.
So that is
that's a good
some
sentence,
new things. There was one question somewhere, reskilling fund.
Yeah.
Yes.
Reskilling fund, I'll just correct the question. That was one word there, laid off. That's not for layoff, that's for retrenchment. That's for retrenchment. And what is that reskilling fund? Suppose I retrench somebody. So I have to pay a compensation in accordance with Section 25F of the Industrial Disputes Act, which is 15 days of average pay per completed year of service. Here what they are saying, 15 days per completed year of service, you pay wages 15 days more. That will be deposited with the appropriate government. And appropriate government will manage that fund, which will be a reskilling fund. Now, just in 15 days wages, how much reskilling would be possible?
They have to give that money to the worker in 45 days. So the government is basically a via media to give another 15 days to that worker. Now, whether he will go and buy a cycle or a scooter or invest in his reskilling, nobody knows.
Yeah. And 15 days is, I mean, nothing.
Monitoring is always a challenge, and that is inherent to the implementation
Exactly.
aspect.
In the code also, that is a thing. So can we use digital means for that? Could there be another way?
End use you can never monitor.
Yes.
Effectively, all you're doing is you're getting any retrenched worker an additional 15 days in the name of reskilling. Now, the concept of retrenchment happens a lot in the industrial sector probably.
Yeah.
In the service sector, there is a stigma, fundamental stigma associated with getting terminated.
Yes.
More often than not, people are encouraged or counseled to resign.
Yeah.
And often with more generous packages, not just like that. Correct? So, eventually nobody is going to get retrenched, or this reskilling money is going to go to the government and to be paid, at least in some sectors. I'm being very, very clear, in some sectors, right? At least in the services sector.
Anyway, that is aimed at job security, and that is aimed at lessening the stigma and things like that, right? And to look at retrenchment not as a personal judgment, but as inadequacy of the skill or misfit to the job. Or
that, ma'am, has been a huge area of debate in courts. What is stigmatic, what is not? It's not just how I define it, it is also social. Nobody likes
it has a human rights implication, yeah. So now we'll finish this questionnaire. We are at the gig and platform workers defined under the code of social security, relying on market. This we finished. We already discussed that. Now, scheme-based social security approach for gig workers, whether it introduces welfare schemes for these gig workers and platform workers, where benefits are provided through government schemes and guaranteed statutory benefits. Is this a good, efficient welfare mechanism? To simplify the question, all those schemes provided under this code. The answer is, there is a skepticism. 15.4% consider it as highly effective, 24% view it as moderately effective, 30% say that it can succeed only if there is adequate funding and implementation support, and then 8.5% said outrightly that it is ineffective, 20% are uncertain. So there's a very mixed approach. Any comment on that, any of you?
At present, what I can immediately see is the nature of the respondents themselves.
Yeah.
All are law students, they have legal knowledge, but practically when you look at the life knowledge, including maternity benefits or something, I think the responses are more logical in nature.
Yeah.
So they have just applied their logical mind, or probably, so this finding itself, it can give a generic, sort of insight on what they hold it as a legal education, students. But as real beneficiaries or people who are probably will be there to efficiently know what will be implemented, that is little different, going to be little different. Ma'am, but when you see everything on paper, there is always a tendency to balance.
Yeah.
But when it comes to implementation, then you will come to know what sort of a pitfall or what we are going to face. Now, when you come to the interpretation itself, that is going to be a quagmire. So the simple terminology with a comma or a full stop is going to mean different for different people and different professionals. So we don't know what is going to be there in store for us. These skeletal legislative frameworks definitely had the prime objective of simplification. But when it comes to implementation, we are going to face a lot of aspects. But I don't feel negative, ma'am. I don't feel negative about
not
most
negative,
of the
but we are objectively debating on the challenge. For
I understood, ma'am. I understood.
Lawyers.
What I am stating is there is a positive approach to seeing everything, and probably we will enable that. That's what I'm saying.
I remember a couplet on this while we are discussing on what will be the impact or implementation.
Yes.
So I remember the couplet there which says, मैं अकेला ही चला था जानबे मंजिल मगर लोग मिलते गए कारवा बनता गया. So we see a lot of new things which are being added. We are debating over here how far they can be implemented, how far they can be practical, but just see that, and we are also comparing ourselves with the EU nations, but just see the size of our nation. I mean, controlling, having so much big population, the vast area that we are confronted with, at least there is a start. And gig workers, they, as rightly pointed out by Maligaon sir, it was never there as a part of the structured, laws as it is seen. So there would be challenges, and we all are here to discuss that. But I'm sure once and as and when the laws come on the floor, they are being tested. The courts also see how well they can be adjusted to our practical needs, and that's how they develop further. Of course, as Ma'am Bhanusri also correctly said, on papers we try and balance the situation. But as and when we proceed further in the practical world, then we notice where are the pitfalls, and that's how law is always amenable to change. It is constantly developing, and that's how I personally see these labor codes.
But here, the data-driven, if we are looking at data-driven legislation making, there's a large percentage of data that has come from the court-centric data or court-created data. But while making the legislation, there are also other stakeholder-related data where, from the practice point of view, when they see a different angle from the litigant point of view, that is where we can argue for more participation of the stakeholders, which government has aptly called for, the stakeholder engagement. I think such insights and media scan could be taken into consideration. That's what I feel. So let's go to question 10. Question 10 is related to our sub-theme in terms of occupational safety, health and working conditions. So question 10 is talking about employers maintaining safe and healthy conditions for workers. So do you think even if it increases the cost of employers, is it going to be positively impacted? They say that yes, it should be there and it is supported. 30% prefer that there should be balanced approach of safeguards and also business feasibility. Business has to, we can have more inventions and innovations there. Let's go to the next question. The next question is shift from tradition inspection regime to inspector come facilitator. As it was rightly told about facilitation, does it strengthen compliance to facilitation? Again, there is cautious optimism, but 38% almost say that strong regulatory oversight is needed. 10% say that it remains uncertain. What do you say about regulatory oversight? Current labor inspectors are a kind of apology for inspection. They say managed or whatever. What do you have to say being in the practice?
No, I feel every maturing economy has to move to a place where you really limit regulatory oversight only to the most critical issues.
I agree.
Right?
True.
That's what we need to focus on.
Yes.
So do you think automatic or self-driven compliance reports are good enough and they're studied and then it is done?
See, India is a very big country. There will always be bad players. There will always be bad players. But like I said, you can't make that as the excuse to continue to have huge amount of regulatory oversight across the board for the smallest of things. Right?
Good point.
We cannot legislate for 2% perpetrators. We have to look and place the trust for 98% of good Samaritans who are going to be entrepreneurs and employers in this country.
Very good point.
So, that is.
Sir,
yeah. No, it's a multifold and a multi-pronged approach. Inspector come facilitators, today they are only inspectors. Overnight, can you change the designation? Yes. But can you change the mental psyche? Can you change the approach? So everything cannot be changed. In fact, these people will require training also.
True. Yeah.
How you have to have a humane approach. I don't want to use some words here, but how they approach factories. Factories, how they handle them. Factories in the sense, factories is generic. But otherwise, every industry, every organization.
So there's a need for training and capacity building.
They
and
capacity
even mindset
building,
changing.
trust. Trust is very important. Today, inspector is, it's a dreaded word itself. Inspector is coming.
Not trust, but pest.
Yeah.
Thank
And then
you very
there are
much.
ways and means. Now you see, under Maharashtra Factories Rules 1963, these are state rules. Maharashtra Factories Rules 1963, the limit is only 3 years. You keep all the documents only for 3 years. Invariably in courts of law, High Court and everywhere, we say, I mean, these are the relevant documents. By the time he understands the documents are relevant, 3 years are already over.
So
And
this
the
can be
companies
overcome
are-
by technology.
Yeah. So this will, no, one more thing.
Yeah.
I learn, I don't know, I may be wrong also, but I learn that government, what they are going to do is, Provident Fund, ESI and income tax, they are going to fix up softwares so they can recheck and cross-check each other. How many employees are there? 100. So 100 should be paying Provident Fund, and income tax from the balance sheet they can make out. So this I learned from somewhere that, I mean, it's yet not there, but tomorrow, maybe for good governance, this is also possible.
Wonderful. Let's go to the last question in the survey. I think this is the last question. Now, if there are any questions from the audience, given the time limit, maybe time for only 2 or 3 questions. We have already done the survey. So, please, 2 to 3 questions. And you can address it to the panel. Introduce yourself. Please.
Due to the paucity of time, we have invited questions from the audience and compiled the same for our esteemed panelists. The first question is for Atul Gupta, sir. The new labour regime under Industrial Relations Code 2020 raises the threshold for prior government approval in layoffs and retrenchment. From an industry perspective, does this reform genuinely encourage long-term job creation, or could it unintentionally incentivize greater contractualization of labour?
Just a quick answer.
Yeah, no, I certainly think it's a move in the right direction. If General Motors is not selling its cars, it should be allowed to shut shop rather than waiting for a decade to get a permission. It just doesn't make sense in today's economy. Pay fair severance, move on.
The funny thing is, General Motors, I appeared on behalf of General Motors in this closure phenomena. Matter was before the Labour Minister. And they said, okay, how much are you going to give the workers? 3,000 workers. So we said 25 lakhs each worker, plus Provident Fund, plus gratuity, making it 30 lakhs per worker. Now the problem in India is, when there is money involved, corporator comes in, MLA creeps in, MP jumps in. So all these people came up. Then the union leader went outside, had a talk on the cell phone with somebody, and then he came back. The Labour Minister, he was Honorable Vaise Patil at that point of time, said, okay, how much do you want per worker? They said, 2 crores. So it was my turn to answer. I said 2 crores per worker multiplied by 3,000. So if I have that much money, why would I close down? And in this money, I can go to the Supreme Court and come back 7 times.
I agree. I would personally feel that there is no place for permission at all. But that's a very controversial view. I would say that we should move away from that. Legislate for better severance. Make it fair.
There's one of school of thought for this 300 threshold. How many industries in India employ more than 300 workers? 20%.
Yeah.
So this is for 80%. 80% are all okay with it.
That is selling out the destiny. Yeah. So, next question, please. Just 2 questions only. You filter the questions if they're repetitive. Yeah.
Our next question is to Advocate Archana Pathak, ma'am. Given the ongoing concerns...
That you can wait. Next question. Yeah.
The 4 labour codes aim to simplify compliance through consolidation, but critics argue that simplification may come at the cost of dilution of protections. From a policy design perspective, how should regulators measure whether the reforms are actually improving labour welfare rather than merely reducing regulatory burden? Banashri ma'am, we would request you to please address this question.
So the welfare definitely has to be prioritized. And when we want welfare legislations to be put in place, less and less regulation is also going to be integral to it. And the liberal interpretations is going to be the basic principle of the court, whether it is going to be based on a consolidated courts, what we are seeing, or even the previous ones. It was always the courts. We don't find much of a judgment, but always the cornerstone of welfare legislation has always been beneficial and liberal interpretations of the courts of our country, which has said that welfare gets predominance over the regulatory oversight or the phenomena in which you want to put restrictions or limitations. So that will continue to be there as the fundamental cornerstone for policymakers also.
Thank you.
Thank you so much,
ma'am,
ma'am.
you had a question. So please shoot the question. Yeah.
Ma'am, given the ongoing concerns about delegated legislation and the wide rule-making powers under the labour codes, how does the government ensure that subordinate rules framed under statutes like the Code on Social Security 2020 remain consistent with constitutional guarantees under the Constitution of India and withstand judicial scrutiny?
See, this is already under the concurrent list, the subject that we are talking about. The rule-making power is both with the centre and the states. The draft rules have already been shared by the centre. So there is already something that is being provided. I've been informed that almost 32 states have already adopted those rules. There are few which have not yet done so. So to maintain the equality of laws, equality of rules, the draft rules are already there. That is the kind of intervention that the centre proposes to make, and that's how we can ensure that there is similarity throughout. Now, state-specific rules, of course, the states can come up with something specific if they want to, but otherwise, generally, the draft rules are there, which are already being provided. So that's what they are trying to ensure at.
Thank you so much, ma'am. And thank you to all our panelists. Before we move towards the formal conclusion of this event, we would like to invite a few words from our esteemed knowledge partner, Ajivika Bureau, whose collaboration has been instrumental in enriching this initiative and strengthening engagement on issues relating to labor governance and the rights of migrant and informal workers.
Thank you, Symbiosis Law College and panelists for the engaging discussion on the new labor codes. Behalf of Ajivika, I would like to thank you, Symbiosis Law College, for engaging us as knowledge partner. I would like to give a brief information about Ajivika Bureau. Ajivika Bureau started in almost before 25 years. 25 साल पहले जब हमारी आजीविका ब्यूरो ने शुरुआत की थी, हमारी शुरुआत जो है वो राजस्थान से हुई थी, और राजस्थान में बहुत सारे जो अनअर्गनाइज्ड सेक्टर्स हैं, माइग्रेंट वर्कर्स हैं, इन सब के साथ जब हम काम कर रहे थे तो हमें ऐसे लग रहा था कि इनके जो डिफरेंट इश्यूज़ हैं उस पर काम करना बहुत ज़रूरी है. बहुत बार इनके वेजेस को लेके रहता है, बहुत बार ऐसे इश्यूज़ रहते हैं कि जहाँ पे हमने बॉन्डेड लेबर के केसेस भी हैंडल किए हैं. रिसेंटली इन फेब लास्ट मंथ में हमने जो अहिल्या नगर है वहाँ पे बॉन्डेड लेबर की केस रेस्क्यू की थी, जहाँ पे एक पूरे 10 से ज़्यादा लेबर्स थे जिनको अनलॉफुल डिटेन करके रखा था, उनके फ़ोन छीन लिए गए थे, उनको फैमिली के साथ कांटेक्ट करने नहीं दिया जा रहा था, और उनकी जो बेसिक राइट टू लाइफ है वो उनसे छीन ली गई थी. तो ये केस जब हमने जो सिस्टम है, हमारे जो कलेक्टर्स है, पुलिस है, रेवेन्यू डिपार्टमेंट है, लेबर डिपार्टमेंट है, इनके साथ मिलके हम लोग इस तरीके की केसेस में काम करते हैं. इसके अलावा पोस्ट कोविड हमने एक डेडिकेटेड हेल्पलाइन शुरू की है. ये हेल्पलाइन मैं एक बार दोहराना चाहूँगी, 1800-833-9020. ये हेल्पलाइन नंबर पे हमने आज तक लगभग 50,000 से ज़्यादा कॉल रिसीव किए हैं. जो लेबर कोड्स में मीडिएशन की बात होती है तो बहुत बार जब स्मॉल स्केल्स में अगर सैलरी के इश्यूज़ है, पीएफ है, ग्रेजुटी से रिलेटेड इशू है, या टर्मिनेशन से रिलेटेड इश्यूज़ है। तो इन सारे मुद्दों पे हमारे जो केस मैनेजर हैं जिनको हमने ट्रेन किया है वो ऑल ओवर द कंट्री इनके पास कॉल आते हैं और वो इस केसेस में एम्प्लॉयर के साथ मिटिगेशन करने की कोशिश करते हैं। यहाँ पे हमने आज तक लगभग 20,000 से ज़्यादा केसेस हमने रिजॉल्व की है और अमाउंट जो है वो लगभग 100 करोड़ से ज़्यादा है। साथ ही में हम लोग ऑक्यूपेशनल सेफ्टी और हेल्थ रिलेटेड जो भी अवेयरनेस है अलग अलग फैक्ट्री में जाके वर्कर्स में जाके वहाँ पे कर रहे हैं। रिसेंटली हमारा एक सर्वे हो रहा है जो जैसे कि गिग वर्कर की यहाँ पे बात हो रही थी, तो जो ऐप बेस्ड डोमेस्टिक वर्कर्स हैं उनके भी बहुत सारे इश्यूज़ उभर के आ रहे हैं। उनमें से एक था कि उनको कहीं पे बैठने के लिए और वेट करने के लिए जगह नहीं होती है, तो उनको 8 घंटा स्टैंड बाय होना होता है और इस वजह से बहुत सारे इश्यूज़ होते हैं। रिसेंटली इन मरोल में ऐसे ही जो एक ऐप बेस्ड वर्कर थी और वो कॉल आने का वेट कर रही थी कि उसको काम पे जाना है और डोमेस्टिक वायलेंस की वजह से उसके पति ने रास्ते पे ही उसका खून किया और वो सेफ प्लेस नहीं है उनके लिए, है ना। वो कहाँ पे वेट करती है, वो गार्डन में वेट करती है, वो रास्ते पे एक चाय की टपरी होती है वहाँ पे वो वेट करती है। तो इस तरीके से उनको कोई भी एक जगह नहीं है जहाँ पे वो मिल सके, वहाँ पे वॉशरूम की सुविधा हो या दूसरी सुविधा हो, जिस वजह से उनको बहुत सारे इश्यूज़ आ रहे हैं। साथ में रेटिंग को लेके भी बहुत सारे इश्यूज़ आ रहे हैं। तो उस पर हम लोग सर्वे कर रहे हैं और उन्हीं वर्कर्स के साथ कर रहे हैं। तो होपफुली हम वो सर्वे भी बहुत जल्दी पब्लिश करेंगे। तो ये ओवरऑल आजीविका और इंडिया लेबर लाइन का काम है। थैंक यू वंस अगेन सिम्बायोसिस लॉ कॉलेज एंड professors and HODs. Thank you.
As we draw closer to the culmination of our event, it is my pleasure to extend our heartfelt gratitude to all those who have contributed to making this occasion a resounding success. At this juncture, allow me to invite Dr. Aprajita Mohanty Ma'am, Deputy Director, Symbiosis Law School, Pune, to present the vote of thanks.
As we come to the end of this intellectually stimulating discussion on rewriting labor laws, assessing the promise and pitfalls of new labor codes, it is my honor and privilege to deliver vote of thanks on behalf of Director and Dean Dr. Sashikala Gurpur. I thank I thank Advocate Archana Pathak, Additional Solicitor General of India, for consenting to be the chief guest and deliver the keynote address, which indeed set the tone for panel discussion. A sincere note of thanks to Advocate Shrikant Malegaonkar Sir, Director of Malegaonkar and Associates, Dr. Banushri Velpandian, Senior Specialist in Law, Research and Networking, Niti Aayog, Mr. Atul Gupta, Partner at Trilegal, for discussing various dimensions and implications of new labor codes. I thank Dr. Gurpur for her guidance as well as vision. Through encouraging events like this, ma'am has been very effectively ensuring learning as well as capacity building on the part of the students. I thank the Conclave team of students who have envisioned and planned the Conclave in terms of research, visualization, as well as logistics. I thank the faculty team of Conclave for their guidance at every stage of planning and execution. Special note of thanks to Dr. Nimisha, Dr. Sujata, and Dr. Ravi. I thank different committees of Symbiosis, such as budget, tech support, as well as the team of program support for ensuring a collective execution of the event. I thank the faculty team of student advisory body for their guidance at every step. And I thank, and above all, I thank the students as well as the faculty who have attended today's conclave. With this, I thank one and I thank all. Over to you.
Thank you so much, ma'am. Now, I would like to kindly request Professor Dr. Shashikala Gurpur, ma'am, and all the esteemed dignitaries to proceed to the conference room for lunch and the faculty members to move to the dining area for the same. The students are requested to remain seated.